Hello and welcome back to the channel. My name is attorney Stanley Helinski and I'm a longtime trial attorney with lots of trial experience. Today we're talking about an issue that is highly misunderstood and on which I'm going to give you a sort of how-to guide: restraining orders. We all know that some unscrupulous lawyers advise clients to obtain these orders just to gain some advantage in the family court. This is truly disgusting, but there's a lot of this kind of nonsense out there and it's what it is. Stay with me. I'll help. What do you do when someone brings one of these petitions against you and the initial order ends up being granted? That initial order is what we call an ex parte order. Well, I'm going to tell you what you need to do to give you the best chance of not having the order continued. I'll do a separate video of what to do when you want to bring one of these petitions against someone else, so be on the lookout for that. It's an entirely different thing. So you were served with a restraining order and have to be back in court within 10 days. Or your 6-month or 1-year continuation date is up and the plaintiff wants a continuance, or even worse, wants to make it permanent. Incidentally, don't miss that date. It's on the back of the restraining order. You won't get any notice in the mail. You just have to show up on that date. Too many of you, and that very much includes lawyers, focus only on proving that the plaintiff has fabricated the allegations. You're going to lose a he said, she said restraining order hearing almost always. I'm not saying that you shouldn't use some of that approach if you have the facts, but you shouldn't limit yourself to that argument. Absolutely not. You'll lose. The thing about restraining orders you need to know, to give you some perspective, is that judges don't really have a downside to granting them. If they grant it and maybe shouldn't, then nothing happens. A defendant gets kicked out of his or her house and is strip searched anytime that he or she is pulled over on the highway. But if they don't grant it, courts and the defendant then goes out and kills the plaintiff that night, God forbid, then the judge is going to be on the first page of the newspaper the next day and will likely be exiled to a bench in the Berkshires. No judge wants that. Years ago, a judge in Superior Court, I won't say her name, let a violent crime defendant out on, I believe, personal recognizance and an arraignment. Sure enough, the same defendant went out and killed the alleged victim that night. Well, that judge, of course, was on the front page of every newspaper in the morning, was demonized for a good while of her decision to release him. And the thing is, she's actually a pretty good judge. But the point is that judges are just lawyers with robes. And despite their lifetime appointments, no judge wants that kind of attention or responsibility. So they grant them. Now, don't get me wrong. There are plenty of discerning judges out there. It's been getting better and better as the years go by, where judges are granting less of these, fewer of these, rather than everyone that comes in the door. But these are still abused significantly, and I mean abused by petitioners, which I guess is kind of ironic. Restraining orders, when properly used, are absolutely a good thing. Don't get me wrong about that. They're just heavily abused and invite perjury. So let me give you a how-to, and first tell you what the law says, because the appeals court and the trial courts who will decide these think along the lines of the law. And I'm not talking about the straightforward case law that we're all sort of aware of, which is that the plaintiff bears the burden of proving the defendant has caused or attempted to cause physical harm, committed a sexual assault, or placed the plaintiff in fear of imminent serious physical harm. That last one is the one upon which most of these orders are based. So that little snippet of law is from McDonald versus Caruso, 467 Mass 382. It's a 2014 case. Google these cases, or I'll pop the link in the description downstairs. It helps to read them. In considering a restraining order, the judge must consider the totality of the circumstances. That comes from the case of Lamele versus Asselin, 831 New England 2nd 324. The nature of the relationship, as well as any prior history of violence, threats, or hostility within it, serve as the necessary backstop for reaching a proper understanding of more recent words or behavior, as well as assessing the plaintiff's reasonableness of fear, the fear of imminent physical harm. And that's from the case of Pike versus Maguire, 47 Mass Appellate Court 930. Another factor that really does matter is when the parties are in court together. In an ongoing custody dispute or litigation of some sort that may cause hostility between them, that's a tough one. It's either there or it isn't. If you do have that in your case, meaning that you're in court with one another, try to get across to the court during your restraining order hearing that you don't hold any hostility against the other party and that you trust the courts to do the right thing. It's the best way to get around that. But let me tell you how to really beat these things. You have to show that since whatever happened that caused the initial order to issue, that the plaintiff has put herself or himself somehow near the defendant, or has done something that has given some indication that he or she is not in actual fear of the defendant anymore. So how is this done? Well, in a family case, just show that the two were just in court together and reached an agreement over temporary orders. That's an easy one. Show that the two agreed over some issue having to do with the children. Show that they transition the kids easily and without incident. Show that the plaintiff has been reaching out to the defendant. The defendant, of course, should never respond if there's a restraining order, but show that the two work collaboratively with the school together. There are so many day-to-day issues that don't even come to mind, but that matter to the court, to show that the plaintiff is no longer in reasonable fear of the defendant. His or her actions are to the contrary. If you have the facts, paint that picture. More than anything, that's what will comfort a judge the most, not to renew the order or continue the order. This comes from the case of Callahan versus Callahan, 85 Mass Appellate Court 369. It's a 2014 case. You absolutely should read that case before you go in on a restraining order, even if you're represented by counsel. I'll include a link below as well with that. Callahan says that a judge must make a discerning appraisal of the continued need for the abuse protection order to protect the plaintiff from the violence already inflicted. I mean, wow. That means if you can minimize the facts upon which the order was initially based, number one, and show, number two, over time, the wound from that incident, even if it existed, which you'll never concede, would have healed by now anyway. And so there's no need to continue the restraining order. That is how you best beat these. So even if something had happened, it was minor enough and enough time has passed that there really isn't any need for an order anymore. Stay tuned for some more ideas that you could add to your argument as well. You must present to the court in a non-threatening demeanor when you're there. Dress for court, present well. You must try the case. These are mini trials. So whatever your theory of the case, the witness is a liar, the witness is mistaken, it was self-defense, it didn't happen, like the witness said it happened, or any combination of these, that's of course part of your presentation. More than anything, if this is a continuation hearing and some time has passed, then you need to minimize the original incident and demonstrate that the wound would have healed by now and the order is no longer necessary. I promise you, many judges get that. I can't tell you which ones, but they get that. In fact, a decision was just handed down by none other than Justice Wolohozian, who was just nominated to the Supreme Judicial Court in the Mass Appeals Court, saying just that. You need to show that there is something going on right now in order for the RO to be continued. Historical harm may, in certain cases, warrant extensions, but continuing harm needs to be shown, and it's the plaintiff's burden to show that. Practically speaking, the defendant should affirmatively disprove the need for a further order despite the plaintiff's burden, because that's just how the system works. That case that was just released this week by Judge Wolohozian is Latoya L versus Kai K. It's docket number 23-P-470, obviously a 2024 case. If you read these cases before you go in, regardless if you're represented by counsel, it will really give you a view in the eyes of the decision makers here. Defeating these frivolous positions is crucial. Restraining orders have a huge consequence in your life. From getting fired from your job, losing firearms if you have a license, and so many other life-changing things. You just don't want a restraining order against you, and I hope I've given you some tools to combat one, particularly frivolous ones. So that's it for now. Tell me in the comments if you've ever beaten one of these on your own. As always, this is not legal advice about your case, but general legal information. If you do have a case that needs to be assessed, you should always consult with a lawyer who will be able to review the facts of your case, the evidence in your case, and the law that applies to your case in order to give you a solid opinion. Do be careful when you're hiring a lawyer out there. Not all lawyers are scrupulous, and this area of the law is certainly no exception. This is a brand new channel. If you like this content, that will have lots of useful legal content from an attorney of 25 years who's been in court his whole life, please consider subscribing to the channel and passing along the information. Thanks very much, and we will see you next time.